The final attorney to speak was Mr. T. Elliott Gazer, Solicitor General for the state of Ohio. Now, as you might expect, Ohio sees the facts of the case differently.
Mr. Chief Justice, and may it please the court, Ohio agrees it is wrong to hold some litigants to a higher standard because of their protected characteristics. But that is not what happened in this case. When Governor DeWine took office in January 2019 and appointed a new cabinet-level director of the Ohio Department of Youth Services, the state's juvenile correction system, petitioner was an unclassified civil servant, effectively an at-will political appointee. She claims the department took 2 adverse actions against her in the first 5 months of the administration, denying her a promotion and demoting her because of her sexual orientation. But after discovery, she could not establish that anybody was motivated by sexual orientation or even knew her sexual orientation, nor the orientation of the unclassified political appointees, Ms. Frierson and Mr. Stoj-Sevljevic, that she points to as comparators.
Wait a second. Doesn't the premise of a majority group include the assumption of membership in that group unless there's evidence to the contrary? Wouldn't it be the assumption that Ms. Ames, Ms. Frierson, and Mr. Stoj-Sevljevic are heterosexual?
In other words, she failed to make out a prima facie case under the first step of McDonnell-Douglas that should apply to every Title VII plaintiff. She didn't provide evidence that, to quote Fernco, if otherwise unexplained, raises an inference of discrimination.
I suppose that would be true if the people who were chosen to fill these 2 positions had applied for the job like the others, had interviewed for the job like the others, and were at least as qualified as the others. Then again, since neither person applied for the job, why were they chosen? Now, one distinguishing factor is their sexual orientation. And since the fundamental assumption of majority groups is that most people are part of them, that seems to be a prima facie case to me.
Whether that evidentiary standard is framed as background circumstances, as in Parker, or circumstances which give rise to an inference of unlawful discrimination, as in Burdine, this court has said a prima facie case under Title VII must be complete enough for the court to enter judgment for the plaintiff before the burden shifts to the employer. Because the best reading of the Sixth Circuit judgment applies that standard, this court should affirm.
Remember this statement because it will become very important during the justice's questioning.
If this court nevertheless holds petitioner made out a prima facie case on these facts, then McDonnell-Douglas has effectively 2 prongs, and the court will have made Title VII that unusual statute that presumes liability for employers and swallows what remains of at-will employment. I welcome the court's questions.
It seems to be the logic of Mr. Gazer's argument is that we got the answer we want, so please don't overturn it. During questioning, I think Mr. Gazer really stepped in it when he answered a question from Justice Kagan.
Mr. Geiser, I mean, you can say, well, there's language. I mean, I think that that's the absolutely critical language in this opinion. Because Ames is heterosexual, she must make a showing in addition to the usual ones for establishing a prima facie case. And then it says, you know, Ames's prima facie case would have been easy to make had she belonged to the relevant minority group, here gay people. So, I mean, this is what the court did.
The Sixth Circuit clearly stated that Ms. Ames' case would have been easily made if she were part of the relevant minority class. Meaning, because she was not gay, she had a higher burden to prove her case had merit. This is where Mr. Gazer had to backpedal.
Well, and we can't retreat from what the court here said, but we think the best way to construe that language is consistent. But nevertheless, I think
the best way to construe that language is like as the language says.
Well, Justice Kagan, yes, the court said what it said. The important point is the prima facie step that this court has laid out needs to be complete enough before the employer has any burden under Title VII to show an inference of discrimination.
So according to Mr. Gazer, the question before the court, if the Sixth Circuit erred, doesn't matter. When the Sixth Circuit denied to review the case, even though they admitted Ms. Ames had made her prima facie case because she was a heterosexual, is not the point. So did she make the prima facie case? The court clearly stated she did.
You agree that those passages are wrong?
We're not defending the exact language there. This per curiam, we asked for...
So let me get this right. Ohio is defending the case, but not the language the court used in the case. I've heard this before from my own lips, but this is a different situation entirely.
The exact language, or you're defending something like that language? I mean, it's a little bit of a peculiar situation, isn't it? Because this is what the court said, and you're up here, and I don't know exactly what to make of this. Do you think that that's right, or do you think that it's wrong?
I think the idea that you hold people to different standards because of their protected characteristics is wrong. And if there's any upshot from this case, let reverse discrimination completely fall out of the federal reporter.
If the state of Ohio believes reverse discrimination is wrong, why are they fighting to prevent a case about reverse discrimination from continuing? I agree, this argument just doesn't make sense.
I guess my reaction to a lot of what you're saying is this. You say you agree with your friends on the question that we took this case to decide. The question presented is whether a majority group plaintiff has to show something more than a minority group plaintiff. Here, whether a straight person has to show more than a gay person. Everybody over here says no. You say no, too. That was the question that we took the case to decide. And now you're asking us to opine on various other aspects of how the McDonnell-Douglas test works, what we should think of the first step as doing, then what we should think of the second and third steps as doing, that are, really not intertwined at all with that question. Whatever McDonnell-Douglas does, it does for majority group plaintiffs and minority group plaintiffs alike, is all that we have to say. Why shouldn't we approach the case in that way?
And attorneys wonder why people hate them. Here you have a simple question presented to the court. A question where all the parties to the case agree the answer should be no, but Mr. Gazer, representing the state of Ohio, doesn't want it reversed. This idea of the ends justify the means is what so many Americans find disgusting about the legal profession.
Well, I think there are two responses to that, Justice Kagan. First of all, while we all agree that everyone should be treated equally, we don't agree about what that prima facie step actually looks like.
Yes, I know. That's exactly what my point is. But that's orthogonal to the question we took. So, I mean, why would we use this case, which is about whether a majority group plaintiff has an extra burden, to opine on a range of things that have nothing to do with that question?
Well, so what the Sixth Circuit did here, this is my second reason, Justice Kagan, if the first one doesn't satisfy you, is exactly what we think every court should do. Ask for enough evidence to raise an inference of discrimination. And simply going through those four prongs, copy-pasting McDonnell-Douglas with subbing out racial minority for any particular protected group doesn't do that. It doesn't satisfy what this court said in Reeves and Burdine in footnote 6 and 7. And so our thought is the court should still affirm, because what the Sixth Circuit's judgment did here is what we ask every court to do at the first step of McDonnell-Douglas, even if we agree that saying that an additional burden is a mischaracterization of what this court has said in the past.
In short, we agree that the circuit court should not have dropped the case because it is unfair, but the state of Ohio doesn't want the Supreme Court to reverse because Ms. Ames hasn't made the case that she has not had a chance to argue yet. I'm sorry, but I find Mr. Gage's argument disgusting.